Today is Wednesday, October 22nd, 2014, the regular meeting of the Information Commission. At the request of the complainants, the Commission is reporting consideration of document 2015-775. Isaiah Avalicia, Andy Thibault, and the Torrington Register Citizen versus Dora Shiro, Commissioner, State of Connecticut, Department of Emergency Services and Border Protection, et al.
Will the parties please identify themselves for the record?
Isaac Avalicia.
Andy Thibault.
Thank you. Who would like to begin?
I'll go ahead and begin. I'm going to go ahead and read from the statement. This case was very simple. It was about prompt production. Did state police fail to fulfill its statutory obligation to turn over records in a prompt fashion when it released a police report 4 months after it was requested? But this case has devolved into a discussion on discretion. Mr. Streeter, your preliminary decision favoring state police unconscionable squelching of public records shows that you exercise no discretion. Instead, you allowed state police to exercise all of the discretion. This is what we feared when the state Supreme Court ruled in favor of police, giving them sole discretion on whether to disclose particular public records to the citizens. But this is the same decision Assistant Attorney General Terrence O'Neill revisited again and again during our hearing, and it sets a sickening precedent. And now, the Commission is being asked to adopt the same position it stringently opposed. Over the years, the FOI Commission earned its stripes as a tiger with temerity, tracking down and pouncing on public officials and agencies whenever they broke open records law. But this decision, the Commission is willingly allowing itself to be defamed. It's telling journalists that an Assistant Attorney General can do a technical tap dance all over a case and win a technical knockout. That's wrong. This case stands and falls on a central question. Is it reasonable for state police to hide a public record for 4 months? The answer is no. The argument can be made that everyone is entitled to the presumption of innocence in a court of law, and the release of public records can taint that presumption. But it's also an instrumental tool journalists use to gauge police conduct and the merits of their investigation. While police aren't obligated to release more than broader information, they are not precluded from doing so, and they should do so to engender public trust. That's the discretion that didn't take place in this case. In closing, I'd like to leave you with some words from one of your own. Victor Perpetua, an attorney who argued the state Supreme Court case I mentioned earlier on behalf of the FOI Commission, said, "In the information world, timely release is everything." The state Supreme Court didn't buy the argument and eventually sided with the state. But long before that decision was made, Lieutenant Paul Vance instructed us on who the real decider of prompt was. It's not the people, it's not the courts, it's the state police. For that very reason, I'm asking you to reject Commissioner Streeter's report. Thank you.
Thank you. My name is Andy Thibault. I'm proud to have worked on this state-sanctioned cover-up with my colleague, Isaac Avalicia. They want to keep a lid on this. Reliable sources in the state police told us from the get-go. We knew what was in the report. We knew there was no good reason, at least in any state pretending to be a democratic republic, to hide this report for 4 months. This draft decision, resulting from a flawed, biased, and unfair hearing, cannot stand. This decision gives police the authority, as State Police Lieutenant Paul Vance puts it, to be the decider of what public information is retrieved by the public, at what time, if at all. This is the definition of a police state. This is not the will of Governor Grasso and the legislature that created Connecticut's FOI law in 1975. The state will cite the Connecticut Supreme Court's butchery of the FOI law as a reason for you to uphold this heinous decision. We ask U.S. citizens, not on behalf of any newspaper or organization, to vote your conscience, to engage in a form of nullification, if you will. You have the power to vote your conscience. Listen to your conscience. No one will drag you away, not yet anyway, for voting to uphold the public's right to know, for voting to correct an injustice. As an aside, this is the same Supreme Court that recently defined black males as, quote, exigent circumstances, unquote, State v. Kendrick, to eviscerate the Fourth Amendment. These robes in particular are not worthy of any deference or respect. There are also other conventional grounds for you to nullify this decision. The hearing officer demonstrated incompetence and bias. He failed to allow the complainants to present their case. This is the core duty of a hearing officer. Instead, time and time again, the hearing officer allowed the assistant AG to cut off the complainants as they tried to present a case. Virtually every objection by the respondents was sustained. Indeed, evidence normally and customarily admitted was disallowed. As for the respondents, at one point the assistant AG scolded my colleague, telling him to behave. Was Terrence O'Neill challenging a sadistic nun? Is he in the wrong vocation? Notably, this scolder himself had been sanctioned recently for unethical behavior by a federal judge. The respondent Vance admitted under oath that although he has no public information or public records to produce, he bizarrely calls himself a public information officer. When asked about his duty to earn the public trust, Vance was baffled. How far down the rabbit hole are you commissioners willing to go? Thank you.
Any comment? Questions? No. You want to address that?
Where to begin? I just want to say that it was a difficult hearing as far as the hands of the commission being tied by the recent decision of the Supreme Court, which was alluded to by both Mr. Lucia and Mr. Thibault. When it came down to it, that's why paragraphs 14, 15, I'm sorry, 14, 15, and 16 dealing with the recent case. I think that I've always prided myself in trying to be a fair and open commissioner, contrary to these aspersions. I know that I had 5 cases on today, and 4 of the 5 cases went for the complainant. I try to uphold the complainant's view, and this probably would have gone the other way as well if we didn't have that court decision. I would recommend you go to the legislature or appeal it in any way so that this can change, and hopefully that'll satisfy you. But I did not try to make this a personal issue with either of you. But I leave it to the will of the commission how they decide to vote.
The commission is bound by the law and has to apply the law whether they like it or not. And you made it clear that the law is not in your favor, and Commissioner Streeter did what he was supposed to do.
More or less.
And with that, I entertain a motion. So
Second.
motion made and seconded. All those in favor?
Aye.
Opposed? Motion carries. Thank you.
Thanks for your time.